Hello viewers, last session we discussed the chapter of biodiversity, law and practice. This session will be dealing with hazardous waste management, law and practice. Under this chapter, we will be dealing with the sources and problems of hazardous waste and also the law pertaining to hazardous waste management in India and also the latest provisions relating to hazardous waste management. We will also see the role of judicial activism in this regard. Let us deal with the introduction of the chapter. Hazardous waste poses a serious threat to human health and the environment. Hazardous waste may be liquid, sludge, solid or gas. Many types of businesses generate hazardous waste. Besides industrial and commercial waste, household waste may also be hazardous. Certain chemicals like pesticides, cleaning agents, old paint and solvents, and even items like fluorescent light bulbs may pose a threat to human health and the environment if not disposed of properly. Improper storage, handling, transportation, treatment and disposal of hazardous waste results in adverse impact on ecosystem and the human environment. Discharge of acidic and alkaline waste affects the natural capacity of surface waters and soil and may result in loss of biodiversity, and hence it is a matter of grave concern. The medical waste was not disposed of properly is also posing serious threat to the health of people at large. Latest and most dangerous form of waste has emerged in the recent time, which is known as e-waste. India, being a party to the Basel Convention on Transboundary Movement of Hazardous Waste, is required to fulfill its objectives regarding control and reduce transboundary movements of hazardous waste. The other objectives of the convention include prevention and minimization of generation of such waste, their environmentally sound management and active reduction of the transfer and use of cleaner technologies. Definition of hazardous waste. Hazardous waste means any waste which by reason of any of its physical, chemical, reactive, toxic, flammable, explosive or corrosive characteristics causes danger or is likely to cause danger to health or environment, whether alone or when in contact with other wastes or substances. Most hazardous waste is generated from metal processing, mining, chemical production or the refining of petroleum. A number of techniques have been used to try to dispose of this type of toxic waste. These techniques include incineration, storage in lagoons and pits, discharge into streams or oceans for dilution, detoxification, injection into deep wells or salt caverns. Despite best intentions to rid the environment of hazardous waste, these substances have caused immense harm to planet Earth. Let us know the sources of hazardous waste. Sources of hazardous waste in India includes those from industrial process, mining, extraction, pesticide-based agricultural practices. Industries that are major producers of hazardous waste include petrochemicals, pharmaceuticals, pesticide plants and paints and dyes, petroleum, fertilizers, asbestos, caustic soda, inorganic chemicals and general engineering. The main source of hazardous waste generation and impact on the environment is the chemical industries. The shipbreaking industries dispose of old ships and recovers the construction material for recycling. Let us deal with the management techniques of hazardous waste. The major components of solid waste are paper, wood and yard waste, glass, metals, plastics and textiles. Primary management techniques for the disposal of these wastes include incineration, which involves the burning of trash and garbage in a large furnace at high temperature. This technique of waste incineration dates back to the late 19th century. Incinerators generate large amounts of toxic waste that is released into the atmosphere. Some of the major pollutants released with combustion include lead, mercury, cadmium, nitrogen oxides, sulfur dioxide, hydrogen chloride, sulfuric acid, fluorides and dioxins. Next technique is of dumps, landfills and ocean dumping. One of the oldest methods of getting rid of waste is dumping these materials on some unwanted land surface. Dumping has been replaced in recent times by sanitary landfills. Dumping often causes the ocean habitat to become polluted. Sometimes ocean pollution from the dumping of waste poisons marine organisms. The role of Government of India. The Government of India has promulgated various rules and guidelines on the management and handling of hazardous waste. These rules are implemented through the state pollution control boards and pollution control committees in states and the union territories. The following strategies are recommended for improving the management of hazardous and solid waste. To ensure the scientific management of hazardous waste, including its generation, segregation, transportation, treatment and disposal. The strategy should also target waste minimization, reduction as its primary focus. More efforts quantifying and characterizing the volume of waste generated by industries. Training and building the capacity of State Pollution Control Board officials are required to prepare an inventory of waste. Comprehensive environmental and social assessments of hazardous waste management operations are needed to minimize the impacts of waste on human health and the ecosystem. To develop technologies for waste collection, treatment and disposal in order to ensure proper solid waste management. Community waste bins must be provided at convenient places to systematize the collection process. Private enterprises and non-governmental organizations should be actively involved in waste collection and its recycling. Governmental standards must be set up not only for disposal of waste on land but also for cleaning up contaminated soils and groundwater. Let us deal with hazardous waste from the Environment Protection Act 1986, the law relating. The Environment Protection Act 1986 is an umbrella legislation which comprehensively deals with environmental problems. Section 6 of the Environment Protection Act 1986 expressly empowered the central government to make rules on various items, including the procedures and safeguards for the handling of hazardous substances and the prohibition and restriction on the handling of hazardous substances in different areas. In the exercise of the powers conferred by Section 6, 8 and 25 of the Environment Protection Act, the central government passed important rules to deal with hazardous waste and toxic chemicals. Following are noteworthy. Hazardous Waste Management and Handling Rules 1989, Biomedical Waste Management and Handling Rules 1998, the E-Waste Management and Handling Rules 2011. Relevant provisions of the Environment Protection Act 1986. Under Section 6, the notification in the Official Gazette make rules to regulate environmental pollution. Under Section 8, no person shall handle or cause to be handled any hazardous substance except in accordance with such procedure and after complying with such safeguards as may be prescribed. The central government may by notification in the Official Gazette make rules for carrying out the purposes of this Act under Section 25. The Hazardous Waste Management Rules 1989. The Ministry of Environment and Forests enacted the umbrella legislation Environment Protection Act in 1986 and an amendment to it in 2002. Subsequently, the Ministry of Environment and Forests promulgated the Hazardous Waste Management and Handling Rules in 1989 and amendments in 2000 and 2002. The efforts to draw up inventories of hazardous waste generated in the country were initiated. Let us deal with the salient features of Hazardous Waste Management and Handling Rules 1989. Indian waste management rules are founded on the principles of sustainable development, precautionary and polluter pays principles, which also mean polluter must bear costs for damages and harm caused to environment by his own acts. These principles form an integral part of Indian environmental law jurisprudence as observed by the Supreme Court of India in various decisions. Specific forms of waste are the subject matter of separate rules and triggers separate compliances, mostly in the nature of authorizations, maintenance of records and adequate disposal mechanisms. Some rules have specific consequences for breach, while in case of some, the general penalty under Environment Protection Act applies, which involves imprisonment of person in charge, director, manager, officer of a company with whose consent or connivance the breach occurred up to 5 years and or a fine up to rupees 1 lakh. Now, the latest Hazardous Waste Management Rules 2016 have come into being. Due to unscientific usage of waste disposal mechanism, lots of problems are being faced by people. Hence, in order to deal with such problems, the Ministry of Environment has updated the Hazardous Waste Management Rules in April 2016. The new rules allow the municipalities to levy user-free for waste management and make individuals responsible for disposal of the garbage. The source segregation of waste has been mandated to channelize the waste to wealth by recovery, reuse and recycle. Procedure has been simplified for setting up of hazardous waste disposal facility and import of other waste by merging all the approvals with the provision for single window clearance. The process of import or export of waste has been streamlined and the list of waste regulated for import or export has been revised. There is no need to obtain Environment Ministry's permission for import of metal scrap, paper waste and various categories of electrical and electronic equipments for reuse purpose. let us deal with the salient features of Biomedical Waste Management and Handling Rules 1998. Biomedical waste means any waste generated in healthcare processes like diagnosis, treatment or immunization of human beings or animals, research activities concerning production or testing of biological beings. Schedule 1 further provides categories of biomedical waste such as human, anatomical, animal, microbiological and biotechnology, discarded medicines, cytotoxic drugs, incineration ash, chemical related waste. The biomedical waste rules are applicable to a wide array of institutions such as hospitals, nursing homes, clinics, dispensaries, veterinary institutions, animal houses, pathological laboratories and blood banks. Rule 8, Clause 1 requires every occupier of an establishment generating or dealing in biomedical waste in any other manner and of a treatment facility to make an application for authorization from the State Pollution Control Board. If there is any breach under the law, punishment is imprisonment up to 5 years or fine up to rupees 1 lakh. Let us now deal with the Solid Waste Management Rules 2016. The Environment Ministry has revised solid waste management rules after 16 years. Some of the salient features of Solid Waste Management Rules 2016 are: the rules are now applicable beyond municipal areas and extend to urban agglomerations, census towns, notified industrial townships, areas under the control of Indian Railways, airports, airbase, port and harbour, defence establishments, special economic zones, the state and central government organizations, places of pilgrims, religious and historical important sites. The source segregation of waste has been mandated to channelize the waste to wealth by recovery, reuse and recycle. Responsibilities of generators have been introduced to segregate waste into 3 streams: wet, biodegradable, dry, plastic, paper, metal, wood, etc., and domestic hazardous waste, diapers, napkins, empty containers of cleaning agents, mosquito repellents, etc., and hand over segregated waste to authorized rag pickers or waste collection or local bodies. The concept of partnership in Swachh Bharat has been introduced. Bulk and institutional generators, market associations, event organizers and hotels and restaurants have been directly made responsible for segregation and sorting the waste and manage in partnership with local bodies. User fee for solid waste management, spot fine for littering have been introduced, which shall also be specified in the bylaws of the local bodies. Now let us deal with the merging problem, salient features of the E-Waste Management and Handling Rules 2011. In the present times, usage of electronic goods has become a routine necessity. People are using goods such as mobile phones and laptops for convenience and comfort, but along with positive elements, these things have negative factors such as disposal of these elements is a big problem, and if it is not done properly may lead to disasters in future. The e-waste rules apply to every producer, consumer or bulk consumer, including factories under the Factories Act, involved in the manufacture, sale, purchase and processing of electronic and electrical equipment or components, along with all collection centers, dismantlers and recyclers of e-waste. E-waste is defined under Rule 3, Clause K to mean waste electrical and electronic equipment in whole or part or as rejects in the manufacturing and repair process which are discarded. As per Rule 4, the producer of electrical and electronic equipments must obtain authorization from State Pollution Control Board and is responsible for collection of e-waste generated in the manufacturing process or after end of life as part of extended producer responsibility. The e-waste rules also delineate the responsibilities of collection centers, consumers, bulk consumers, dismantlers and recyclers. Non-compliance with the provisions of e-waste rules may result in cancellation or suspension of the authorization. The rules expressly mention the principle of extended producer responsibility. As its name implies, this means that a producer's responsibility extends not only throughout the lifetime of the product but also the proper disposal of the product. An important innovation is the placing of the obligation on the producer to create awareness through awareness publications, advertisements, posters concerning the hazardous constituents. The E-Waste Management and Handling Rules 2016. The Ministry of Environment, Forest and Climate Change notified the E-Waste Management Rules 2016 on 23rd March 2016 in supersession of the E-Waste Management and Handling Rules 2011. Under this, the manufacturer, dealer, refurbisher and producer responsibility organization have been introduced as additional stakeholders in the rules. The applicability of the rules has been extended to components, consumables, spares and parts of EEE in addition to equipment as listed in Schedule 1. Collection and channelizing of e-waste in extended producer responsibility authorization shall be in line with the targets prescribed in Schedule 3 of the rules. The roles of the state government has been also introduced in the rules in order to ensure safety, health and skill development of the workers involved in the dismantling and recycling operations. Liability for damages caused to the environment or third party due to improper management of e-waste, including provision for levying financial penalty for violation of provision of the rules, has also been introduced. Urban local bodies, municipal committee, council, corporation have been assigned the duty to collect and channelize the orphan products to dismantle or recycle. Now let us deal with the judicial activism in this waste management field. Research Foundation for Science, Technology and Natural Resource Policy versus Union of India and others. In December 2001, the Supreme Court had directed the Ministry of Environment and Forests to conduct an inquiry and take appropriate disappearance of hazardous waste from various ports, internal container depot and container freight stations. The interim ruling was issued on a writ petition filed by the Research Foundation for Science, Technology and Natural Resource Policy of India and others. The background to this ruling was the original Supreme Court judgment in May 1997 banning import of hazardous waste, followed by subsequent order disallowing auction of hazardous waste stocks in the country, ports and container depots. Next case is of BL Vadera versus Union of India, AIR 1996 SC 2969, Part 2. Facts of the case. The petitioner, an advocate of the Supreme Court, prayed to the court to issue necessary directions to the Municipal Corporation of Delhi and New Delhi Municipal Committee, requiring both the authorities to perform their statutory duties, in particular to the collection, removal of garbage and other waste in the city of Delhi. In this case, the court observed that it is not clear from the affidavit whether the incinerator is in working condition or out of order. The court issued 14 directions in this case. 4 of them are related to biomedical waste, which are as follows. All hospitals with 50 beds and above should install incinerators or any of effective alternative method under their own administrative control. All India Institute of Medical Sciences, New Delhi, through its director, installed sufficient number of incinerators or any equally effective alternative to dispose of hospital waste. Municipal Corporation of Delhi and New Delhi Municipal Corporation issue notices to all the private hospitals and nursing homes in the city of Delhi to make their own arrangements for the disposal of their garbage and hospital waste. They may be asked to construct their own incinerators. The Central Pollution Control Board and the State Pollution Control Boards should regularly send its inspection teams in different areas to ascertain the collection, transportation and disposal. The court held that the authorities concerned have a mandatory duty to collect and dispose of the garbage and waste generated from various sources in the city. The court further pointed out that the river Yamuna, the main source of drinking water supply, was the free dumping place for untreated sewage and industrial waste. The next case is of Almira Patel versus Union of India 1998 to SCC 4161. In this case, the Supreme Court appointed a committee to examine all aspects of urban solid waste management in Class 1 cities having population over 1 lakh and directed to submit its report by 30th of June 1998. Next case is Almira Patel versus Union of India AIR 2000 SC 1256 Part 2. The attention of Supreme Court was drawn to the 14 directions in BL Vadera case. The court showed its deep anguish regarding the non-observance of directions and said in these words, "It is indeed unfortunate that till today the said directions have not been complied with." Dear viewers, I hope you enjoyed this session. The next class we will be dealing with transboundary pollution. Thank you.